appealing the matter of Yehuda Tescher Limited and Direct Accident Management Ltd and AXA Insurance UK.
Yes, good morning, Mr. Mallew. Good morning, Mr. Williams.
Good morning.
Very nice to see you both. Before we start, can I say we've read the papers. We think we have a lively appreciation of the issues, but we're going to welcome your submissions. Just before we start, can I find out, have you agreed a timetable between you?
We have, my lord. We're hoping to keep it fairly straightforward. Your lordships and your ladyship will be aware there's a respondent's notice here, but the way I intended to approach it, and I think Mr. Williams agrees, is that I'm going to essentially open both appeals and deal with all of the issues of principle in both appeals, including those raised by the respondent's notice, which essentially overlap with the issues that are raised in the other appeal anyway. And so I anticipate I will take until the middle of this afternoon to do that, probably somewhere between 2:30 and 3 o'clock. At that point, Mr. Williams will take over and take us through the afternoon and through most of tomorrow, leaving somewhere in the region of 15 minutes or so, we anticipate, for dealing with any replies.
Fine, okay. Well, that would be good. We have other commitments such that we do need to finish at 1 tomorrow, but and I imagine that by 20 to 1 tomorrow afternoon the grass will have been well trampled, so I don't imagine that replies would be that long, but it is important that you have a short right of reply, so that timetable sounds very sensible.
My lord, I'm very grateful. Obviously we will be directed as your lordships wish as the hearing proceeds, but that's our initial proposal.
Right.
So, my lord, my ladies, I appear for the appellants in both matters. Mr. Williams, King's Counsel, appears for the respondents in both matters. He appears with Mr. Hogan in the Tescher and Dams matter, which I'll refer to as the Dams appeal, and with Mr. Wazak in the AXA and Spectra appeal, which I will refer to as the Spectra appeal. My lords, my lady, just to check the housekeeping, if I may, you should have 4 bundles, a DAMS core bundle and supplemental bundle, a Spectra bundle and an authorities bundle.
Yes.
I'm grateful. I've mentioned already just the one sort of small procedural wrinkle. There's no issue between us in terms of the procedure in relation to this. There is a respondent's notice in the Spectra appeal. The Spectra appeal itself was originally on what could be seen as quite a narrow point, which was essentially what I'll describe as the good fortune point. The decision of His Honour Judge Gargan that my client had enjoyed good fortune because the claimant had discontinued her claim when she would not have been found to have been fundamentally dishonest had it proceeded to trial. The respondent's notice puts back in issue the points that His Honour Judge Gargan found in my client's favour, the interest, real party points, the control point, the causation point, and the quox point. But as I've already indicated, those are issues which are already raised in the DAMS appeal. So my intention will be to deal with those points as essentially a combined points of principle as we deal with those points. And so the respondent's notice shouldn't derail the timetable. The only other short procedural point, which again I hope won't delay us, your lordships have all the skeletons in the bundle. There is a supplemental skeleton from me in the Spectra bundle at page 73 in response to the respondent's notice. Strictly speaking, my lords, I require permission for that respondent's that skeleton argument in response to the respondent's notice.
Right. Well, I'm bound to say I thought somewhere along the line that permission had been given, but we certainly
I don't
give that permission. That's the one at 73 to 84. It runs from pages 73 to 84.
That's the one, my lord. Yes.
And Mr. Williams says no.
No, certainly no objection, my lord.
No, thank you. Yeah.
Well, thank you. In that case, that's subject to any points your lordships, your ladyship have. That's the procedure. Turning then to the appeals, Lord, I think it was my Lord Justice Coulson who said in the Gochner case, which we'll come to, for those who believe that most civil litigation does not end up being about costs that were incurred in pursuing that litigation, look away now. Well,
I
Lord,
do slightly regret that, although that did win me the prestigious Civil Lit blog Starting Paragraph of the Year Award 2023. These are the things that, keep an LJ going.
Well, my Lord, I assume that there's a competition for 2025, so that there's potential there yet.
Yeah.
My Lord, I was simply going to observe that for those who have that belief, they should perhaps continue to avert their eyes, because these appeals are unashamedly about cost issues. Perhaps of more immediate relevance, Mr. Justice Turner in the Select and Esure case, which we will come to, refers to the fact that for a quarter of a century, insurance companies and credit hire organisations have been fighting a forensic war of attrition over an ever-broadening front. And this appeal, which was an appeal against a non-party cost order, marked the most recent skirmish, and it was not likely to be the last. Now, my Lord, that was in 2017, following a non-party cost order made in 2015. And whether we describe it as a skirmish or a battle, it has been a regular feature of county court litigation for many years, heightened perhaps following the Jackson reforms in 2013, as to whether and when non-party cost orders should be made in credit hire cases. And that, in essence, is why we are here. As your lordships will have seen, we have, on our part, unashamedly asked this court for guidance on this issue. Judges including circuit judges at the appellate level, have called for that guidance. Your lordships, your ladyship will have seen the comments, no doubt, of His Honour Judge Saunders when granting permission to appeal in the DAMS case, page 82 of the DAMS bundle, just for your reference, and His Honour Judge Gargan in the Spectra case, at paragraph 188 of his judgment, page 133 of the Spectra bundle, just for your lordship's reference. So we do invite this court to hopefully make life a little easier for judges routinely dealing with such cases by providing some guidance in this regard. And as I'm sure your lordships and your ladyship will have seen, we have set out in some terms, we've been bold enough, I hope not too bold, in setting out in some terms at paragraph 68 onwards of our appeal skeleton argument in the DAMS case, which is page 36 of the DAMS bundle. We have proposed a sort of framework for that guidance, which obviously your lordships and ladyship will consider.
Let me just remind myself of that.
So, Lord, that's in the DAMS bundle. It should be, I hope, page 36. And it's paragraph 68 onwards, headed Conclusions as to the framework in relation to non-party cost orders against CHCs, credit hire companies.
Yeah.
Now, obviously, whether we are right about that and whether your lordships and ladyship choose to adopt it or adopt a different form is entirely a matter for you, but we say guidance of that type is likely to be of assistance to those who deal with these matters on the ground. And indeed, we hope that the effect of these appeals will be to reduce the amount of litigation that is necessary in this situation, just as, for example, to use in a different context, whilst we occasionally have disputes about the facts, the disputes, for example, about the principles of non-party cost orders against third-party funders are now rarely an issue. Those principles are well established, the guidance to support them is well established. What tends to be an issue occasionally is application to the facts. So, my Lord, that's a brief introduction. Can I turn then to the appeals themselves? Lord Justice Coulson's indicated that you have you're familiar with the papers, so I'll take this fairly shortly, but it's important just to pick up a few points about the facts.
Yeah.
So the DAMS appeal, as you will know, is an appeal against the decision of District Judge Jeffs of the 2nd of August 2023, where he dismissed an application for a non-party costs order. That case itself, the underlying case itself, was a liability disputed road traffic accident claim. A collision between a car and a motorcycle. Who was at fault was an issue. and the claim itself was ultimately dismissed at trial by District Judge Swan on the 8th of December 2022. In terms of the facts of that, your Lordships have a chronology at page 63 of the DAMS bundle, which covers most of the key points. Just picking up on a few points by reference to that chronology and supplementing them with just a few references to assist your Lordships in their judgment. So, as you will see, the road traffic accident occurred on the 19th of November of 2018. Mr. Quesada was a courier. He was on his motorcycle. Mr. Tescher was in his car. And as I say, the question of who was responsible for the accident was in issue. And also Mr. Quesada was put to proof in relation to his losses if the accident was Mr. Tescher's fault. Those losses you can most clearly see set out in the particulars of claim, which start on page 85. And so we have on page 86, we can see the key losses claimed. Paragraph 4, there was the damage to the vehicle, which was written off and had a pre-accident value of just over £2,000, the end of paragraph 4. There was then a period of claimed hire, credit hire. You can see the rates at paragraph 6, and we come to the totals in just a moment. We can see that in paragraphs 7 through to 9, the credit hire was claimed on the basis of impecuniosity, referred to in all 3 paragraphs. Then if we come further down that page, there were recovery charges, paragraph 13. There was vehicle storage charge. The number seems to be missing off, but it's the paragraph 14, the last paragraph on that page. And then there was a claim for general damages, injuries to the neck and back. And then we can see the particulars of the special damages, the hire claim, by far the biggest element of the claim, for the period of hire, just over £19,500. So just coming back then to the chronology at page 63. That gives us the dates of the credit hire agreement. There were in fact 2 credit hire agreements. As I understand it, there was one vehicle which was hired for 4 days and then a second vehicle hired for the longer period. So that's why there are 2 dates, but there's no difference, no material difference in the terms of the credit hire agreements, and I'll just take you to one in due course. You have the date in the middle of that page that the hire ended, issue of proceedings, defence filed, and then the trial before District Judge Swan, where the claim was dismissed, and then the issue of non-party costs arose, going to the hearing before the District Judge. That hearing was, I think it's fair to say, extended. It took place on the 10th of May. They were then dismissed on the 2nd of August, and then we have the appeal. So that is the appeal that now comes before you. I can assist further in relation to the facts of the case, but really we don't need more in terms of facts than just those core facts, unless there's anything I can assist your Lordship with. Coming then to the Spectra case, a little more complicated, but not unduly complicated in terms of its facts. The appeal in that case is an appeal, in fact, against the decision of His Honour Judge Gargan of the 9th of December 2024. As your Lordship will have seen, what happened is that His Honour Judge Gargan allowed an appeal against Deputy District Judge Carson's decision to make a non-party costs order. He concluded that the District Judge had got it wrong, but he then remade the decision, essentially de novo, and concluded for different reasons that a non-party cost order would have made. Should not have been made. And our appeal is against that different reason he gave, essentially the good fortune point. And as already indicated, the respondent's notice essentially reopens the majority of the issues below. In terms of the Spectra appeal and the facts, there is a chronology in your bundle at page 90, but if I may, I'm going to take you to the slightly fuller description of the facts, which is in my skeleton argument, which starts at page 30, it should be, of the Spectra bundle.
Starting at 36.
That is indeed so, my Lord, thank you.
Yeah.
And so again, we can see the date of the accident. So this accident, the broad nature of this accident, this was again, this was a car-to-car bump. In this case, it was a case where liability was admitted from an early stage and the pre-accident value was paid. But then, as we will see at a considerably later stage, an issue of fundamental dishonesty was raised, raising the question of whether in fact the claimant had needed and had indeed used the car, or whether it had been used by somebody else. And in very short order, in response to that issue having been raised, the claimant discontinued her claim. So this claim did not proceed to trial. So again, I'm not going to read them all out, but the key facts are set out. So the date of the accident was the 23rd of October, Roman 1. The claimant contacted the claims management company and was put in touch with Spectra, the credit hire company, and solicitors DGM. There was, as is common in these cases, recovery and storage, and in due course there was a claim for recovery and storage, Roman 3, just short of £4,000. In passing, I just note that the claimant claimed for general damages, again, soft tissue injuries, neck, left shoulder, left armpit, right arm, and fear of travel. Just for your Lordship's reference, those are set out in the particulars of claim at B214, page 214 of the bundle, but I don't invite you to turn it up. There was a credit hire, and we'll come to the terms of the agreement in a little while. So Roman 5, the credit hire, the total claim for credit hire just short of £12,000. Again, the credit hire was claimed on the basis that the claimant was impecunious. That's at page 215 in the particulars of claim. And then it may just assist just briefly to turn up the schedule of special damages, which is at page 217. And you can see there the various claims set out. So physiotherapy charges, then the hire of the alternative vehicle, then the recovery and storage charges. There was no claim in the particulars of claim or the schedule of special damage for pre-accident value. That was because the liability had been admitted and pre-accident value had been paid. At least I assume that's why there was no such claim.
So the pre-action value had already been paid by the time the schedule was prepared?
Had already been paid, my Lord, yes.
Yeah.
So just coming back then to the skeleton argument, picking back up at paragraph 32, page 32. Roman 10, we can see that liability admitted very early stage, 28th of October, so that's just 5 days after the accident. 11, claimants in touch with Spectra. We can then skip on to 13 at the bottom of the page, when Spectra present the claim to AXA, the insurers, for the higher cost engineers fees, storage and recovery charges, asking for a cheque payable to Spectra. I'm going to skip on over the next page to 16, which is the issue of the claim form. Claim value between £15,000 and £20,000. And I've conducted there a brief analysis, which was the same as the analysis conducted below, as to what that indicates as to the maximum likely value of the general damages, which was on those figures a maximum of just over £3,800. We then come to Roman 17, the sending of a Part 36 offer, which is a material fact here. So the 18th of November 2020, so this is the time when liability is admitted, AXA send a Part 36 offer to the claimant solicitors for the general damages only in the sum of £27.50. There's a response, comes sometime later after the end of the relevant period, but there's a response saying that the claim could not be settled on a piecemeal basis and asking for an offer to settle the whole of the claim. That's a matter that we and the judge below attach some weight to as an indication that the substantial interest in this claim was that of the credit hire company. So by this stage, as I say, liability was admitted, the claimant had been paid her pre-accident value, she'd been offered what we would say was more than an adequate sum for general damages, and nothing's been put forward since to indicate why that sum was not adequate, and the balance of her claim related almost entirely, as we say, to the sums considered by Spectra to be its outlay. We come over the page to page 34, Roman 20. On the 25th of May, so some considerable time after that Part 36 offer, the issue of fundamental dishonesty was raised. And within 3 days, the claimant discontinued her claim. Her evidence, as your lordships will no doubt be aware, there was a hearing as to whether she was fundamentally dishonest in due course. You don't have all the documents from that. But her evidence at that hearing was that she discontinued on advice from DGM on the basis that she was told that she was facing a threat of prison. Because of the discontinuance, a standard deemed order for costs arose, and then an application was issued for a finding of fundamental dishonesty against the claimant. The purpose of that, as again, we'll come to this, but I'm sure your lordships are aware, under the Quox rules, a finding of fundamental dishonesty disapplies the Quox rules and therefore would have made the claimant vulnerable to paying the adverse costs, and or for an order for a non-party costs order against Spectra, which then went through the usual procedural hurdles. That matter then came on for a hearing in front of Deputy District Judge Carson. It took quite a while to resolve, unfortunately. So there was a hearing on the 18th of February. There was then a further hearing on May 2022, and then in June 2022, with judgment being sent out in draft in March 23 and a hand down in August of 2023. At the first hearing, Deputy District Judge Carson decided that the claimant had not been fundamentally dishonest, so the issue that ran on was whether a non-party costs order should be made against Spectra. If it assists, the best place to find a summary of those proceedings is on Judge Gargan's judgment, page 99, page 99, paragraphs 29 to 31. I don't think we need to go through the fine detail of them unless it would assist. Can I then come to, unless there are any questions on the facts, can I then come to the credit hire agreements themselves? Mm-hmm. And can I start, since I think we're in the Spectra bundle, can I start with the Spectra document, which starts on page 231. and the relevant terms are then on 232. So it's a two-page document. First page has the dates, the signatures, the basic provisions for insurance, etc., etc. And then over the page we have the conditions of hire. And so just in terms of these are all highlighted in our skeleton argument for your lordship's reference in terms of the Spectra. This is set out in the Spectra skeleton argument, which is at page 31 of your bundle, this section, but just to highlight the relevant terms, clause 10 says, you will at our request do all required by us and permit his name. There are some odd sort of typos in these conditions. His name to be used by us for enforcing any rights or remedies against the parties in connection with the vehicle.
Mm-hmm.
If we then come down to clauses 18, 19 and 20, which deal with termination. So 18 provides for termination if, in the inspector's opinion, you'll be unable to recover any of the ongoing hire charges. 19, immediate termination if we believe you've given us any information which is false or misleading, or you've breached the terms of the agreement in any significant respect. That's immediate termination for any significant breach. And then at 20, the effect of termination, again, there's something of a typo here. Where we terminate this agreement under clause 4.8, there is no clause 4.8. We suggested below that this was intended to refer to the previous clause, and I don't understand that to have been disputed. So where we terminate the agreement under, we say, the previous clause, any unpaid hire or repair charges become due and payable immediately. You must return the hire vehicle immediately. We can recover the vehicle from you. You will meet our expenses, etc. I'll then pick it then up again at little e. We may instruct the body shop to stop any work in progress on your vehicle. We may retain or instruct the body shop to retain your own vehicle until all total hire charges have been paid. So the combined effect of that is we say that if there is any significant breach of these agreements, there is an immediate obligation to pay the full amount of the hire or repair charges. And of course this won't apply in a case where the vehicle has been written off, but it would apply in a case where the vehicle was being repaired. There is essentially a lien exercised over the claimant's own vehicle until they pay the full amount of those hire charges, which, in parentheses, we say, of course, they're going to be unable to pay because the fundamental premise of these agreements is that the claimant is impecunious and can't afford to hire even at basic rates, let alone at the enhanced credit hire rates. We will come in due course, the Lords, to see how these sorts of agreements have been categorised, both by this court previously and by the High Court in a number of cases. But just to sort of tee up, I'm sure your Lordships are already anticipating it, but the argument that comes, this is part of the effective control that the credit hire company has by virtue of these agreements. That, we say, is enhanced by what we see on page 234, which is the form of authority and mitigation questionnaire. And this gives us a real insight to how these, I'm sure your Lordships are very familiar with how these matters work, but into how these matters work in practice. So this is, although this is an unsigned version, as I understand, it's not in dispute that this was a document that the claimant signed on the same day that she signed.
It actually is signed, if that assists. What has happened, it's an electronic signature, and there must have been some glitch in the system, and it's been misplaced on the page. But if the court sees roughly in the centre of the page is
where there's over typing.
That is in fact the e-signature that has unfortunately been inserted in the wrong place. And Mr. Manu's quite right, it's common ground, it was signed.
I'm grateful for Mr. Williams for
and we can see the date of the 23rd of October.
Yes.
in the middle of the page there.
Yes, we can see that floating. What was on the left wasn't quite clear to me, but I'm grateful to Mr. Williams for clarifying that.
Okay,
So it wasn't an issue anyway that it had been signed on that date, but now we can see what's happened with the signature, so I'm very grateful for that. So this is the claimant, and we can see what it says. So she, at the very top, authorises and requests Spectra to recover all uninsured losses, so not just the credit hire, all of her uninsured losses arising from the RTA. She also authorises the company to appoint a solicitor where necessary on her behalf, which she appreciates doesn't restrict her right to instruct a solicitor of her choice, but she confirms that she hasn't already instructed a solicitor or claims recovery agent. She agrees not to accept any payment in settlement from any other source, and then she authorises the solicitor to disclose to Spectra any or all relevant details, including, I note, offers, or any other developments relating to the claim, and then she undertakes to cooperate fully with the company or the solicitor at all times. So we say that the combined effect of these together is that the claimant, it's made clear to the claimant she's instructing and giving authority to Spectra to recover all of her uninsured losses. She is undertaking to cooperate fully, not just with her solicitor, but also with Spectra at all times. She's permitting them to have all material information in relation to her claim. And we've already seen the terms of the credit hire contract itself as to what her obligations are and what the consequences are.
I mean, this is a particularly critical document.
We say it is, yes. But, lady, if I may, we say that this is nothing unusual in terms of the way these things operate. We will see a number of examples, not just the DAMS example, but because they're referred to in the authorities, a number of other examples. And this approach of essentially requiring cooperation with the stick behind it, that if you don't, we can seek full repayment forthwith and or with frills added on by way of exercising liens over your car, it is a typical situation. And can I be clear about this? And I hope we've been clear about this in this Carton. We don't say this is improper. We're not advancing this on the basis that this is in some way unenforceable or improper. But our case is that it shows the reality of these matters. And as we'll come to, but as this court will well know, one of the fundamental points about the exercise of the Section 51 jurisdiction in relation to non-party costs orders is that the court is not bound by contractual niceties and legal niceties, but is enjoined to look at the economic reality of these situations. And we say these are important to understanding that economic reality. So, Lords, unless there is anything on the Spectra terms of agreement that I can assist with at this stage, and maybe we have some questions later, but I'm going to move on to the DAMS version, which means swapping bundles, swapping tablets in my case. And can we then come, there are two of them, I'll introduce both of them, but then just spend time on one. They're at page 113 of the bundle, and then the second version is at 115, but they're identical in all material terms. The one at 113 is the earlier of the two, and so unless your lordships have already marked up a different one, I'll work from the copy at 113. So again, similar form. I should note, because it was the motorcycle division of DAMS, the agreement is headed McCams at the top right, but if you look just above the red typing at the very bottom, you will see McCams is a trading division of Direct Accident Management Ltd.
Sorry, where are you reading from?
So your lordships would see a cancellation notice at the bottom of 113. Immediately above that, there's some, in my version, red typing with an address, and then the small typing just above that, which says McCams is a trading division of Direct Accident Management Ltd. So that's just to explain why we see a different name on this from the name that's on the pleading. Right. Lord, in terms of this, then the real meat again is over the page 114.
Yeah.
Terms and conditions of hire. Clause 5, So where the hire is consequent upon the hirer's own vehicle being unroadworthy as a result of an RTA, which is, again, the starting premise of these hires. One deals with the deferment of hire. I'm not going to delay on that. Little 2, the hirer shall diligently pursue a claim for the hire charges against the third party, shall appoint solicitors nominated by the lessor, so that's DAMS for this purpose. The hirer shall thereafter use all reasonable endeavours to recover the hire charges from the third party, shall fully cooperate with the lessor and the appointed solicitors in this respect. So different wording, but not dissimilar obligation to that we've seen in the previous agreement.
And it's the wording shall 4 times.
Yes, so it's an obligation. There's no doubt it's an obligation. And it's not just an obligation to pursue a claim for the hire charges. It's an obligation at, obviously, DAM's election to appoint solicitors DAM's nominate. An obligation to essentially do everything reasonably required, and an obligation to fully cooperate, not just with the solicitors, but with the lessor. Again, we don't say there's anything improper in that, but it's important to understand what the obligations are. And then we see the consequences at 6. It's interesting to note, if and only if the hirer is in default of condition 5.2, so no other conditions, then the deferred payment facility allowed by the lessor to the hirer shall be terminated. The hire charges will be due from the hirer to the lessor 14 days from the giving of notice to the hirer by reference to this condition 6. So if you don't diligently pursue, if you don't appoint the solicitors we nominate, if we choose to nominate solicitors, if you don't use all reasonable endeavours, and if you don't fully cooperate both with us and the solicitors, the consequence is you, the impecunious claimant, within 14 days shall pay us in full the hire charges that you will never be able to pay us. There is a further obligation at 10, which I don't attach too much weight to in this context, but I just highlight it. The hirer will, at the request of the lessor, do all required by the lessor and permit his name to be used by the lessor for enforcing any rights or remedies against the parties in connection with the vehicle. I would accept that is probably primarily directed to what precedes it in 9, which is if you have a bump whilst you're in our hire car, and you've got to help us and pursue anybody else we say is responsible for that bump. But it is it's an obligation that's not drawn specifically by reference to clause 9, and it's a broad obligation again to do essentially whatever the lessor requires you to do. We say in broad terms that the combined effect of these documents is similar in both cases and is similar to what we see in other cases. You'll be aware that we're going to come briefly to cases involving a hire company called Kinderton's, which is one of the decisions that Mr. Justice Turner dealt with, a hire company called Select, which is another company, and we will also see slightly earlier iterations of the DAMS terms in a case called Farrell, which this court dealt with. And we will see core aspects of all of them, which are essentially very similar. Can I then come to the second aspect, unless your lordships have any questions on those terms? The second aspect of documents that we say are relevant in this DAMS case, which are in the supplementary bundle. Supplemental bundle, whichever description it's been given, and they start at page 80. And so we have 2 documents. One is an admission statement, which starts on page 80, from the Annexo Group, which is the parent company of DAMS, which is part of the Annexo Group, and we'll see something about the structure when we just briefly look through this in a moment. So this is an admission statement which was produced in June 2018 for Annexo's admission to the alternative investment market. And then we will also come to see an annual report that was produced by the group in 2022. We'll come to that in just a minute. As far as we are aware, and it's not been suggested, there's nothing in these documents which changed in substance by the time the relevant agreements that we are looking at were entered into. There is a more detailed analysis of these documents at paragraphs 25 to 34 of my skeleton argument in the DAMS case, which I rely on, but I'm not going to take you all through that. I'm just going to highlight some key parts now for the purposes of my submissions.
Yeah.
And also, I want to be clear about these documents. We don't say that these documents in the DAMS case are what makes the difference. We don't say this is the smoking gun that we found that means that DAMS should be subject to a non-party costs order and others shouldn't. What we say is simply that these shine a light on what we can already see is the reality of this situation, but they just really bring the point home as to what's going on in these cases. So it's going to be a little bit of a skipping about in the document, but I hope it will make some kind of sense. Can I pick it up, please, at page 88?
Yeah.
So this gives an overview of the group, and as we'll see in the very first sentence on that page, the group is a specialist integrated credit hire and legal services group focused on providing replacement vehicles and associated legal services to impecunious customers who've been involved in a no-fault accident. So that's the target market, and we can see that repeated. The third paragraph, which has some indented sections, the first of those, the first bullet point, is the group's business model is built on the impecunious customer. And we can see that again at the fourth bullet point. It's focused on the impecunious customer. And the reason for that, we can see also, we're told at the fourth bullet point, is it allows the group to recover significantly higher rates than spot hire or GTA rates. So there's a sound...
GTA stands for?
I don't know.
It stands for the Association of British Insurers General Terms of Agreement, because what the court probably might not necessarily apprehend is the cases that get litigated at the tip of an iceberg. The majority of these cases get settled through industry protocols, and that's the ABI GTA, which prescribes certain rates of hire. And but if a case is litigated, that goes out of the window. This court has said it's irrelevant in a previous case, but that's the reference. So they're saying you get higher rates with impecunious customers than you would under the ABI General Terms of Agreement, under which many other cases are compromised.
So GTA is the General Terms
of Agreement, my lord, and that is an agreement between the Association of British Insurers and various participating credit hire organisations.
Right. Okay, thank you very much.
I suspect I was one of the few other people in this room who didn't know the answer to that question, but I'm very grateful for Mr. Williams' knowledge. So, my lord, if I can then just come back up to the second paragraph on that page, and I'm just going to highlight the second sentence in that second paragraph, which says the group provides an integrated end-to-end service to the customer, including provision of a credit hire vehicle, upfront settlement of repair and recovery charges, through to the management, recovery of costs, and the processing of any associated personal injury claim. And I just highlight in particular those last few words, because we will see later on in these documents clear references to the idea that in these sorts of claims, the personal injury claim is essentially a byproduct. It's something that gets picked up on the way through as part of the overarching credit hire claim.
Mr. Mallew, I'm not suggesting there's a need to go through it, but speaking for myself, I did find paragraph 2, background and history, interesting. The development.
Milady, I'm content to take your, of course, your lordships to it. There is a very
There's a lady
detailed...
here as well as the lordships.
Sorry, lady.
That's right.
Sorry, milady. I apologise, of course.
Well, you're not the first.
Well, I hope I will be the last. Thank you, milady. Milady, your lordships, yes, there is a detailed background there. I wasn't planning on taking you through it, but it does give a helpful history. DAMS has been around for quite some time, as we will see when we come to look at the Farrell case, and it sets out the 4 integrated aspects in the 4 bullet points at the bottom of that page, and indeed gives quite an interesting history over the page of some of the key case law that's happened. Again, focusing in particular, as you'll see on the case of Lagdon and O'Connor, and the role of impecunious clients and the higher rates that permits recovery of. I'm Again, if there are particular points it would assist to highlight, I'm happy to, but I'm not going to delay your relationship and your lordships with that. If I can pick it up then, having gone over the page, at the bottom of page 89, because we just see the final paragraph there, the business provides vehicles to individuals who've been involved in a non-fault accident, that's the aim at least, allowing the recovery of costs from the at-fault insurer at no upfront cost to the customer. Sales activities are focused exclusively on the impecunious market, allowing the group to charge commercial credit hire rates, which are typically 2 to 3 times higher than the rates agreed by the ABI and the GTA, which, courtesy of Mr. Williams, we now know what that means. Over the page at 90, the second paragraph, the group has a claims vetting process which is critical both to prevent fraud and ensure the ultimate recovery of the claim from the at-fault insurer. And again, this is a thread throughout all of this, the idea that the business operates on recoveries of the credit hire from the at-fault insurer, not the recovery of the higher costs from the claimant.
I'm sorry, Mr. Malley, what was the reference
Sorry,
to that?
my Lord, the second paragraph on page 90.
Thank you.
Beginning the group's claims vetting process. And then it goes on to note the directors believe success rates of 99% in 2017, success being where neither the group nor the customer is required to make a payment. And so that's an indication of the quality that's said of the vetting process. If we then come on to page 91, we can see references to Bond Turner. So Bond Turner was the claimant solicitor here. Bond Turner is part of the Anexo group, as it is DAMS. And then we can see at the bottom of that page, Bond Turner operates within 3 key areas: credit hire, recovery of credit hire debts owed to Edge, which is the name. We saw that from the background and history. Edge is the name that's used within the group to describe both DAMS, McCAMS and CAMS, which are the 3 divisions that actually hire the cars out. So that's the credit hire business that's being referred to by the term Edge. So back to page 91, recovery of credit hire debts owed to the credit hire companies from individuals who've been provided with a vehicle, whilst the debt associated with the hire is legally for the individual to settle, and that's of course a point Mr. Williams attaches much weight to and we don't dispute. The group prides itself in the majority of cases on recovering all such costs from the at-fault insurer. In 2017, credit hire and associated claims work was in excess of 95% of Bond Turner revenue. And then personal injury. Most RTA cases referred by Edge include an element of PI, although this is a byproduct of a credit hire claim rather than the focus of the business. If we can come on then, my lady, my lords, to page 92, there's more said about the way the integrated approach works. I'm just going to pick up the first full paragraph on that page, beginning the directors believe. I'm just going to pick up the last sentence of that paragraph where it refers to the integrated approach allows management to make decisions for the overall group, maximising recovery from both legal fees and higher charges. So again, just to try and be clear in this case, we entirely accept that Bond Turner were the claimant's solicitors and had to act on the claimant's instructions. But what we do say can be seen from these cases it is that the credit hire companies essentially are able to exercise a degree of control, at the very least over the credit hire aspect of the case, because they are able, of course, to say what they are prepared to settle the credit hire claim for. If, for example, they are prepared to take less for the credit hire claim than the credit hire claim is valued at itself, then of course that would wipe out any suggestion of any balancing debt owed by the claimant for the residue of that credit hire claim. And of course, if they work closely with solicitors who take instructions from the claimant but are familiar with what the credit hire companies will be prepared to take in a typical claim, then of course that makes it much easier for those solicitors to advise the clients in relation to proposed settlements with defendants. Just picking that up on page 92, we can see the claims process then is described in the middle of page 92. In the vast majority of cases, including instances where the circumstances of the accident or the hire charges are disputed, the at-fault insurer may refuse to settle the claim at a higher rate acceptable to the group. In order to maintain momentum and to secure settlement, Bond Turner will typically issue court proceedings. If no settlement is agreed and the case proceeds to court, Bond Turner will instruct either in-house barristers or barristers from a panel, etc., etc. So a key determinant of the issue of proceedings is whether the at-fault insurer, as they're described, will settle the claim at a higher rate acceptable to the group. And then the final paragraph under that section, the vast majority of claims are settled by negotiation, partly driven by the group's need to preserve working capital. This has historically restricted settlement recovery rates to about 50 to 60% of the gross hire claim. So what we've seen is that 99% of the cases settle without any claim against the claimants, but the typical settlement is 50 to 60% of the gross hire claim, because the fundamental operation of this is the credit hire claim works on the idea that it's essentially a non-recourse agreement, usually, as against the claimant. The hire company will take what it can get from the at-fault insurer. The only recourse, in practical terms, against the claimant is the threat that if the claimant doesn't cooperate, they can be visited with the debt.
Just on the paragraph, the first claims process paragraph, in the middle there it says there's an average of around 10 barristers in court each day representing the group's clients. So does that mean that there are, on this basis, can I infer there's an average of 10 cases at every day of the working day of the year in the county court?
That appears to be what it suggests, but again, almost everybody else in this room will probably know more about that than I do. So
I knew there were a lot of them, but I didn't know. That's interesting if that's what that means.
And this is, of course, some years ago, so whether that still represents the number, I couldn't say. And of course, that is, if it does represent the number, that is just in respect of this one credit hire group. And there are quite a number of others. Over the page, it may just be helpful by way of background, page 93, but there is a market and regulatory background, and my lady, your lordships will just see that at a number of places, for example, in the middle of the first paragraph on that, under that heading, there's reference to the group serving claimants who have been deemed to be impecunious, and then there's some setting out of the history of the law of impecuniosity in this context. I'm nearly finished in terms of this document, and then just a quick couple of bits in a second document, and we'll be out of this material. Page 95. Here, obviously, the company is group is promoting itself as to why it's worth investing in, but in that paragraph at the top of the page, third sentence in, there's reference to the group's integrated service, helping the group maintain quality at each stage and effectively manage the process with the legal division motivated to recover the credit hire charges for the benefit of the wider group. The group is not, unlike most participants in the sector, reliant on generating PI claims that may not be cost-effective to process on a standalone basis. However, the group is able to increase fees recovered as part of a core credit hire claim by also processing associated PI claims. So again, this is just an indication that, certainly from the group's perspective, the PI seems to be, if anything, almost something of a nuisance, save that it allows them to increase the fees recovery as part of what from their perspective is and always was the core credit hire claim. Lord and Lady, if I can then come on, there's a second document which is the annual report, which is at page 133 from 2022. So page 133. Just a couple of brief extracts from this. On the very first page, again, you'll see under the big bold heading, the little paragraph on the left next to all the numbers just summarises what the company does, charging credit hire rather than spot hire rates, recovering the charges from the at-fault insurer at no upfront cost to the individual, alongside legal fees for the group.
Sorry, where are you reading from?
Sorry, my lord. On page 133,
Oh,
there's a big bold heading, and then there's some little writing just underneath it on the left.
Yeah. Thank you.
And then if we can come on within that, if I can just invite you to come on to page 135, there's a helpful little flow chart. So we can see the process, at least within this group. So Edge, again, for our purposes, Edge is synonymous with DAMS. So there's a flow chart in relation to Edge at the top. You can see from the accident through to the vetting of the claim. We see underneath that, I think that's an about 50% of claims result in a vehicle being issued. So there's a vetting process, which means that, as we've seen, they're looking for no-fault claims where the claimant's impecunious. The rest of the claims get vetted out, and then it comes down to Bond Turner, who are the solicitors appointed by the claimant, in this case and typically. And Bond Turner's role is, if we see it put quite prettily, it's to collect cash from the at-fault insurer. And then underneath that we have a flow chart as to how that happens. It contacts the at-fault insurer with a credit hire and repairs claim. Most cases also include a PI claim. Should the insurer refuse to settle at an acceptable rate, so that's a reference back to the references we've already seen, which is the acceptable rate for credit hire, Bond Turner issues court proceedings. Now, of course, Bond Turner must act, they've been in breach of their SRA duties, must act on the instructions of the claimant. But as we know, the claimants are bound to take all reasonable steps to comply with the credit hire company and to take all reasonable steps to recover the credit hire claim. So if you have a situation where solicitors are used to working with the credit hire companies, they know what the credit hire companies are likely to accept by way of settlement, it is unsurprising that you end up in a situation where the experienced solicitor is able to inform their client as to what is likely to be an acceptable settlement to the credit hire company and therefore whether proceedings should be issued or not.
And to a claimant who may have limited or no experience of a claim of this nature.
Indeed, the solicitors undoubtedly have huge experience, as we've seen. Hopefully for claimants, we all hope that if we have a road traffic accident, it's a one-off. Just the last two references over the page at page 136. We just get some idea of the numbers. So this is the annual report, as I understand it, for 2022. Top of that page, 6,187 high cases settled, 10,265 new cases funded. Now, funded, I'm sure, I'm not going to take a cheap point, I hope. Well, I may have already taken some, but I hope I'm not going to take this one. Funded doesn't mean, of course, funded in the sense that they pay the claimant solicitors or anything of that kind. There is, inevitably in these cases, a retainer, a contracted retainer between the claimant and their solicitors. But it's an interesting use, and we'll see what the Court of Appeal said in this context when we come to the Farrell case, about this idea of de facto funding by provision of the credit hire to the claimant. Final point I seek to draw from this is on page 140. So just to introduce this part of the document, this is, as we see at the top of page 139, this is the Risk and Regulation Committee report, part of the annual report. And then at page 140, under the heading of litigation risk at the bottom of the page, we see a heading in the middle of the page, risk description. The group is a highly litigious firm. Adverse costs arising from litigation will negatively impact the group's results, as well as cause potential reputational damage from losing cases. So the point I draw from that is that the idea of a credit hire company like this being exposed to adverse costs in relation at least to the credit hire part of the litigation is no surprise to them. It is a business risk.
Interesting that the mitigation refers to draconian court orders.
I'd highlighted that, but I wasn't going to refer to it. I'm not sure quite what they mean.
Rather
by
begs the
draconian
question
court orders.
what is covered by that. But
Indeed.
Yeah.
Views can, of course, differ on the merits of orders that the courts make.
Yes, but this is all in the context that there's amongst the risks is a litigation risk. And a risk is adverse cost.
Yes, my lord.
And so your more straightforward point is that, therefore, they accept that they are going to face adverse cost orders from time to time.
Yes.
Yeah.
And we say that's nothing of a surprise. We'll come in a little while briefly to the House of Lords decision of Giles and Thompson, but we'll see in that reference even. Back in that case, to the idea that where claims fail, which have been supported by credit hire, the imposition of costs orders on credit hire companies will impose a healthy discipline on them. So the idea that credit hire companies are exposed to non-party cost orders should come as no real surprise to them. And indeed, it's probably one of the reasons why, of all the disputes we see in these cases, one of the disputes we see very rarely is the idea that the credit hire company wasn't on notice of the risk of exposure. It has been argued in some cases, not very successfully, but it's not routinely argued, presumably because it wouldn't be a good point. So, my lords, my lady, that's all I have to say in relation to the facts, unless there are particular aspects of the facts or the documents that I can assist with. If not, I'm going to dive into the authorities, where we'll be for a little while. And so my intended structure, subject to any contrary direction from the court, was that I was going to spend just a little time looking at some general propositions about non-party cost orders, but I know that those propositions will be very familiar already to this court, so I'm just going to highlight some key points. Then I'm going to spend a little time on what the authorities have to say about the issue of causation in non-party cost orders. Then I was going to come to what we can take from the civil procedure rules, and in particular Rule 44.16 and the practice direction in relation to quocs. And then I was going to come to look at what the cases say about the application of the general principles for non-party costs in the context of credit hire companies.
Okay.
So if I can start with the first proposition. So tab 20, page 446, should I hope be the case of Deutsche Bank and Sebastian Holdings. So this is, as I'm sure the court's familiar with it, but as many of these cases are, this is one of those cases from that fairly developed area of the non-party cost law, which is to do with directors or controlling shareholders of companies and the circumstances in which they can be liable for non-party costs. But again, I'm just relying on it for issues of principle, not fact. And if I can pick it up at page 449, so the judgment was given by Lord Justice Moore-Bick, and he gives a history of some of the key points in relation to non-party costs, starting with Section 51 of the Senior Courts Act, then reference at paragraph 14 to Aid and Shipping Co. and Interbulk. So that was the case where the court first held that Section 51 permitted the making of non-party costs orders. We can then see reference to Symphony Group and Hodgson. And then over the page, we have the well-known citation of the dictum of Lord Justice Bolcombe from that case, paragraph 15. The court will have seen this, I'm sure, on many an occasion, but for present purposes, all I'm going to highlight is just two parts of it. The first is subparagraph 1, an order for payment of costs by a non-party will always be exceptional, and the judge should treat any such application with considerable caution. We'll come to see, but as we know from later cases, but I'll just come to highlight it briefly. Exceptional means no more than it's outside the usual run of cases. I've made the point in my skeleton, and I'll touch on it again later. It can't be said, and the respondents here don't attempt to say, that if in certain categories of cases non-party costs orders are routine, that infringes the exceptionality principle. So, for example, again, in the field of third-party funding, if a third party funds a case for reward, it is routine that third party will be exposed to a non-party costs order if the litigation fails. The fact that it's routine in that context does not breach the exceptionality principle.
Well, you have to be slightly careful about exceptionality anyway, because you're talking it's exceptional as against the general run of civil litigation.
Yes, exactly.
And in cases that involve, let's say, insurers, so where an insurer is involved in making decisions and potentially exposing themselves to a non-party costs order, that is, in one sense, exceptional because it is the involvement of a third party. Most civil litigations between A and B.
Indeed, or even put more simply, my lord, the norm is that the parties on opposite sides of the litigation pay the costs if it goes wrong. That is the norm.
Yeah.
So making it a non-party costs order is inevitably an exception to that norm. But all it means is that it isn't the norm, provided there are good reasons for it and it satisfies the overall test of being just. Then that is the fundamental criterion. At the bottom of the page, can I just highlight subparagraph 9, because this will come back to this in the context of quocs. So this is where Lord Justice Bolcombe sounded a warning as to needing to be alert to the possibility that an application for a non-party costs order is motivated by resentment at an inability to obtain an effective order for costs against a legally aided litigant. Because that, of course, as we know, those increasingly rare beasts, legally aided litigants, have the benefit of statutory adverse cost protection. Now, that point is relied on by the respondents to say that's what my clients are doing here. We are aggrieved, resent the presence of quocs, which would prevent us going against the claimant personally, and therefore are misusing and breaching the principles of quocs by seeking to go against the credit hire company. I'll come back to this specifically later, but just by way of teeing the point up, we don't accept that at all for two reasons. First of all, this is no more than a warning. It's not saying you can't have non-party costs orders in those circumstances. It's just saying it's a warning to make sure they are actually justified. But if they are justified, the fact the claimant themselves is insulated from paying those costs, it is no reason not to make the order. The second point we say is that in a broad sense, it is, in this context, far more just that the non-party may pay the reasonable element of the cost than the claimant would. And if we are correct that the person with the real financial interest in the credit hire claim is the credit hire company, then it's a classic case where it would be more just that they pay than the claimant did. And it's not just akin or analogous to a personal injury case back in the days when personal injury litigants did have legal aid, where that personal injury litigant may have brought their case and they had legal aid and there's nothing more to it than that. And defendants might try to go against the solicitors who'd been complying with their usual duties because they were aggrieved. It's a case where we say the actual proper and just target is the credit hire company. And the third point, which I'll develop a little, is that we say that it can't be said we are acting contrary to the principle of quote by doing this, when the very quote rules that protect the claimant tell us that this is what we should be thinking of doing. They tell us both in the rules and the practice direction that if the claim can be seen to be brought for the financial benefit of a third person, we should be looking to that third person by way of non-party costs order and not looking to the claimant.
That's the Rule 44 point.
That's 44.16 2A and 44.16.3, and it's paragraph 12 of the practice direction. But I'll take your lordships to both of those, which are in the authorities bundle at the appropriate point. So obviously your lordships will be familiar with the full dicta from Symphony Group. Can I then take you over the page, using this case as shorthand in many ways, to paragraph 19, where there's a citation from one of the other very well-known cases here, which is the Privy Council's decision in Dimmock's Franchise Systems and Todd, which, whilst a Privy Council decision has been cited so often by the courts, that of course it has the full force of authority. Here we can just bottom out some of those points. So the dictum from Lord Brown that starts at the bottom of that page, the very last sentence starts with paragraph 1 of his summary, or number 1 of his summary, which is that although costs orders against non-parties are to be regarded as exceptional, exceptional means no more than outside the ordinary run of cases. So the point that we've just addressed. And his next sentence makes the point that we have just considered. The ultimate question in any such exceptional case is whether in all the circumstances it's just to make the order. Sub 2 deals with pure funders, which I won't bother you with, and then sub 3 refers to where, however, the non-party not merely funds the proceedings but substantially also controls, or at any rate is to benefit from them, justice will ordinarily require that if the proceedings fail, you pay the successful party costs. The non-party in these cases is not so much facilitating access to justice by the party funded as himself gaining access to justice for his own purposes. He himself is the real party to the litigation, a concept repeatedly invoked throughout the jurisprudence. Just 2 observations, if I may, in relation to that. It splits into 2 parts, really. The first is that we should be wary of treating the first sentence of that as some sort of mandatory checklist. It's a set of indicia that we should consider, factors to be considered, not a mandatory checklist, and I'll come back to some further authority on that. As to the second sentence, the second part of that citation, as we will come to see, we say it is not. So we say it is possible, and indeed in certain circumstances likely, that there can in fact be more than one real party to litigation. So, for example, you could have a claimant who, of course, has an interest in the claim, but that doesn't stop the court seeing another party, such as the credit hire company, as also having an interest in that claim. And as being a real party for the purposes of the non-party cost order jurisdiction. Now, in saying that, and we'll come to it very shortly, the Lord Justice Coulson in the Gocknor case made it clear that in the context of directors, where the question is whether the claim is being brought for the benefit of the company, we wouldn't really expect to see anything other than one real party. It's either the company's claim or it's being brought for the benefit of the director. It's something of a binary issue in that context. But we say that that's obviously correct in that context, but not necessarily correct in other contexts. And as I understand it, but I'll be corrected, obviously, the Lord Justice Coulson wasn't intending it to be in anything other than the context he was considering. If I can then, on the same page, direct your Lordship, Your Ladyship, to paragraph 21. Lord Justice Moore-Bick noted that the principles have been applied in a number of cases. Subsequent cases are necessary to consider in detail because they all turn to a greater or less degree on their own facts. When an order for costs is sought against a third party, the critical factor in each case is the nature and degree of his connection with the proceedings. And then in the last sentence, it's important to note, however, that contrary to Mr. Cogley's submission, the guidance given in Symphony has not been regarded as immutable, but has been developed and modified in subsequent cases to reflect the differing circumstances under which applications for orders of this kind have been made. And that's the very point that we are making as to why we are here. Differing guidance has been developed in differing contexts, and we are seeking guidance in this specific context. Finally, if we can come to page 460 and 461 in this authority. So in the postscript of paragraph 62, Lord Justice Moore-Bick, about 5 lines from the bottom, just repeats the point about what exceptionality means, the sentence beginning, thus the Privy Council. And then over the page, second line, he says, we think it important to emphasise that the only immutable principle is that the discretion must be exercised justly. Now, as your Lordships and your Ladyship will be aware, Lord Briggs in the Supreme Court in the XYZ case, which we'll come to in just a moment, accepted that as probably being correct, but with a degree of reservation, because he was a little unhappy about the idea of such a broad principle. But it does indeed appear to be the position. May I then direct your Lordships, your Ladyships to tab 13, page 370. It should be the case of Meyer to National Coal Board number 2.
Are we still under the heading of general principles?
We are, my Lord. I'm going to be about another 5 to 10 minutes on general principles.
No, it's fine. I'm just finding out what I am from my notes. Yep, so the next one is...
Meyer to National Coal Board number 2, page 370, tab 13.
Yeah.
So this is a case from the days of the CFA wars, Additional Fee Agreement wars. It was to do with claims brought by former coal miners for noise-induced hearing loss, where those claimants had an interest in the success of the technical challenge on appeal, had it succeeded, which it didn't. But the solicitors themselves also had an interest because they had many CFAs which would be affected if the technical challenge failed, which it did. So the matter went before the Court of Appeal, and in Meyer to National Coal Board number 1, they found against the claimants and in practical terms against the solicitors, and then this is the judgment on an application for a non-party costs order against the claimant solicitors, which was granted in the sum of 50% of the defendant's costs of the appeal. The judgment is given by Lord Justice Dyson, and if I can just pick it up at the top, well, I'll start at the bottom of page 373, because this completes the missing part of the quotation from Dimmock's that we've just seen in the previous case. So 373 starts with the same quotation, but then over the page, at the top of the page, we can see the end of that quotation, which wasn't in the previous citation. Nor indeed is it necessary that the non-party be the only real party to the litigation in the sense explained in the Knight case, provided that he is a real party in very important and critical respects.
So the additional quote starts at the bottom of 373 consistently with this approach.
It does.
Yeah. Yeah.
And that is endorsed, if it assists, at letter G on the same page by Lord Justice Dyson, as he then was, about 4 lines down in paragraph 11, where he says, "It is at this point salutary to recall that Lord Brown said that the non-party need not be the only real party to the litigation." And again, he then quotes the dictum from the Dimmock's case. My Lord, can I then turn to the decision of this court in the case of Gochner, the leading judgment given by my Lord Justice Coulson, my Lord, my Lady, which is tab 26, page 637. So this was, again, an application against a director and indeed shareholder of a company, and it's in that context that the Lord Justice Coulson gave general guidance. We can see, starting on page 641, paragraph 27, citation again of Dimmock's, so the general background to non-party cost orders. And then at page 643, we come to a summary given by the Lord in relation to the position in relation to directors and shareholders. And again, the point the Lord makes at the start is, without in any way suggesting that these authorities give rise to a sort of mandatory checklist applicable to a company director or shareholder, I consider that relevant guidance can be summarised in this way. And again, I'm not going to read all of it out, but if we come over the page to page 644, letter E, your Lordships, your Ladyship may recall when I sounded the warning note about treating those references to control and funding as some sort of checklist. And Lord Justice Coulson said this in this case at letter E. In this way, matters such as control and or funding, and particularly the alleged personal benefit to the director of doing so, are helpful indicia as to whether or not a Section 51 order would be just, but they remain merely elements of the guidance given by the authorities, not a checklist that needs to be completed in every case. Lord, can I then come to page 646, paragraph 53? Just 2 points on this page. The first is at paragraph 53, where the court stood back and looked at the underlying economic reality, and we say that is exactly the correct thing to do in non-party cost order cases. The second point, just to complete the references, is at paragraph 54, when the Lord noted that at one point during the argument, Mr. Benson, who was for the appellant, suggested that even if the company was the real party to the litigation, the director and shareholder was the real party too. And it's there that my Lord said that on the facts and for the reasons you've given, you didn't accept it, but, the next sentence, the concept of there being two real parties, one the company and the other the relevant director or shareholder, introduced a level of complication and granularity which found no reflection in any of the authorities, and would be nigh impossible to apply in practice, because necessarily a benefit to any small company is also a benefit to the director and or shareholder, and that such a concept may distract the court when faced with a Section 51 application from looking at the matter all round and deciding whether the director or shareholder in question can properly be termed the real party. Now again, I'm entirely aware of the tribunal I have in front of me when I make these comments, but in my submission those were comments made very specifically in the context of guidance given in the director shareholder company situation, where it's easy to see why really it's something of a binary issue,
Well, it certainly was in that case.
Yes. And more generally, indeed, in that context, because what the court is really looking at is, undoubtedly the litigation was brought. Was it brought because it was the director using the company as a vehicle to bring litigation in his interests, or was it brought in the company's interests? And if it was one, it wasn't the other, and vice versa. As we've seen, both in the Dimmock's case and in the Myatt case, it's been made clear in other authorities that a party can be a real party, even if there are other real parties. And we would suggest, respectfully, that in other contexts, that binary decision that is faced in the director-shareholder company cases does not necessarily arise. And in particular, in this context, for example, we entirely accept that the claimant had an interest in the claim that she brought in terms of the DAMS case, in terms of the Spectra case, or he brought in terms of the DAMS case. They had a personal injury claim, they had other aspects of their claim, they had an interest in the credit hire. They were liable under the credit hire contract. They have to be. But we say that does not stop seeing the relevant credit hire company as being a real party for the purposes of non-party cost orders on the basis of the authorities. Lord, in terms of general principles, final case is a case called Threlfall, which is page 444. Sorry, I apologise, I've got the page wrong. It's page 439 in your bundle, which is tab 19, Lords, my lady. So that's a decision of this court in 2013. And it's another director case, judgment given by Lord Justice Lewison. And the only point I highlight here is page 444, paragraph 13. The argument was run, as it is often run, and certainly was often run, that an order for non-party costs against a company director would be piercing the corporate veil. And that argument got short shrift then, as it's got short shrift since. And the reason we can see is that about 10 or 11 lines up from the bottom, there's a sentence beginning, "Of course, it's not enough merely to say that Mr. Whitney was a director of ECD. But in deciding whether or not to make such an order," so that's a non-party costs order, "the court is not fettered by the legal realities. It is entitled to look at the economic realities. It is in this sense that many of the cases pose the question whether the non-party is the real party in the case." So, my lords, my lady, subject to any questions, those authorities cover all I want to say for present purposes in relation to general principles for both my clients, because the DAMS case came first and dealt with wider issues until the respondent's case came in the Spectra case. The core points we want to make in relation to that are contained in the DAMS skeleton argument as general principles, and I'll just give your lordship, your ladyship, the reference. That's page 29 of the DAMS bundle, paragraphs 35 to 38. If it would assist with the summary of the points that I've made in our skeleton argument.
Just give me those paragraphs again.
So, my lord, it's page 29 of the DAMS bundle,
Yeah.
It's paragraphs 35 to 38.
Thank you.
My lady, my lords, can I then move to the question of causation and its relevance in the non-party costs order context? And so the starting point for this, not chronologically, but just in terms of consideration of the issues, is the Supreme Court decision in the case of XYZ. And that is tab 24, page 514.
Yeah.
So, again, just to set a little bit of the context to this, this was a case dealing with the liability of product liability insurers, their potential exposure to non-party costs orders. So the important context to this is what we're dealing with here is insurers who have prior to the incident event, a pre-existing contract of insurance with their client, under which they are obliged to indemnify that client. And the unusual context, one moment, just misplaced my notes. The unusual context in relation to the XYZ case was that in this case, some of the claimant's claims were the company that was being sued was insured for them by Travellers Insurance, and some of the claims that the company failed, it wasn't insured for them by Travellers Insurance. And what happened in due course is that the uninsured claims were successful. The company itself, a company called Transform, wasn't able to pay the costs. It went into administration. So those successful claimants from the uninsured claims sought costs against the insurer of the insured claims on the basis essentially that that insurer had conducted the defence, instructed solicitors, funded the defence, etc., etc. And so it was the successful claimants in the uninsured claims who were pursuing a non-party costs order against the insurer of the insured claims. And the ultimate decision of the Supreme Court was that no non-party costs order should have been made because the insurer, which had pre-existing obligations to support its insured in defending the insured claims, was doing nothing improper. It wasn't improperly intermeddling by the fact that in doing so it also therefore was defending and funding the defence of the uninsured claims.
And what happened to the insured claims?
What happened to the insured claims? They, as I understand it, they were met, so they were met under the policy.
Yeah.
So in terms of issues of principle, if we can pick it up at page 524, which is the judgment of Lord Briggs, with whom Lady Black and Lord Kitchen agreed. Paragraph 30, Lord Briggs said, "It's not the purpose of this judgment comprehensively to reassess the generally applicable principles." So there's a background to the history of non-party costs orders over the previous 2 pages. It may be, and he was reluctantly prepared to assume, but without deciding, that they really are limited, as the Court of Appeal thought in the present case, to the twin considerations of exceptionality and justice. And then he noted the Deutsche Bank case, which we've already seen, and shared Lord Reed's concerns as to the lack of content, principle or precision in the concept of exceptionality as a useful test. And as we've seen, exceptionality really doesn't take us very far, and it seems, as the Court of Appeal said, the only immutable principle is justice. So, but then he goes on, just below letter B, that this is an occasion to consider in more granular detail the principles which ought to apply to that distinct part of the broad spectrum of non-parties occupied by liability insurers. So just interposing there, what the Supreme Court's being asked to do is something similar to what we're asking and what's happened in other cases, which is to give specific guidance for a specific context. He goes on, whilst doing so, it would be appropriate to make some brief observations about the impact of the general principles in the liability insurance context, and in particular about the role played by the presence or absence of a causative link between the conduct of the non-party relied on and the costs which the applicants incurred, which they seek to recover. And I just pick up, whilst we're on this page, letter E, paragraph 31, Lord Briggs noted that the context he's dealing with is that the liability insurer is therefore typically an involuntary rather than voluntary funder of litigation, and the control which it exercises arises from its pre-existing contractual entitlement rather than from a freely made decision to intermeddle. So that's the context in which the guidance is given. If we can then come on to page 5 to 9. No, apologies, sorry, my lady, my lords, that's the wrong page. If we can then come on to page 532. Lord Briggs comes to consider the question of causation.
Mm-hmm.
He refers back to a Court of Appeal decision of Cormac, which again was an insurer case, where he refers to the Court of Appeal having endorsed the requirement for an applicant to demonstrate a causative link between the incurring of costs sought to be recovered and some part of the conduct of the non-party alleged to attract the jurisdiction. He notes that that requirement is, in his view, rightly imposed. Lord Justice Old regarded it as part of the exceptionality requirement. It could equally be seen as going to the justice or otherwise of making the order. If the costs would still have been incurred if the non-party hadn't conducted itself in the relevant manner, why should it be just to visit the non-party with liability for them? And then he notes over the page that the causation requirement was not in fact the subject of any challenge on this appeal. It doesn't appear to have featured in the other Chapman cases. And then the next sentence he says, in cases such as the present, where it's the intermeddling test rather than the real defendant test which falls to be applied, the formulation of the test by Lord Justice Phillips in the Chapman case clearly incorporates a need to demonstrate causation, since it's the costs attributable to the intermeddling that the meddler is ordered to pay. So just pausing there, all we do with this section is sound a note of caution as to the context in which the Supreme Court is giving guidance, both generally and by reference to what Lord Briggs says at paragraph 66, where the court obviously didn't hear argument on the issue because it wasn't the subject of challenge, and he makes specific reference to endorsing the Chapman dicta in the context of the intermeddling test, which is not... XYZ was all about intermeddling, because it was the question of whether the insurer intermeddled in cases that it shouldn't be interfering with, i.e. the uninsured cases. It was not a real party case. And so I know that the respondents seek to attach much to these paragraphs, but we say that there should be caution in doing so, and we will see how different courts, including this court, have approached the question of causation in other contexts. My learned friend also relies on the dictum of Lord Reid, who gave a separate judgment, which starts on page 536, separate but concurring judgment, page 536, so he concurred in the outcome. And if I can take you within that to page 538. So the key part, as I understand it, that's relied on is what we see at page 538, letter H, the last sentence, where it's said by Lord Reid, it's in any event noteworthy that the Lord Chancellor's dictum, we'll come to see where that dictum is from, expressly mentions the need for a causal connection between the conduct of the non-party and the incurring of the cost for which he's liable. If we can just then come a little further up that page, paragraph 90 that we're in, to see the genesis for all of this. So in particular, Lord Reid makes reference, starting at paragraph 90, to a case called In re Jones. And that's a case where the solicitor has indemnified a claimant, a plaintiff in the suit against the cost of the suit, and has control of the suit. And it was said in re Jones back in 1870, he will be ordered to pay to the defendants their costs of the suit when dismissed. I mean, that's quite an interesting case in the sense that, of course, 1870 was long before the Arkin case and long before the foundation of the Section 51 jurisdiction to make non-party costs orders, but nevertheless it was established that if you had a situation where a solicitor went so far as to indemnify a plaintiff against the cost of the suit and had control of the suit, it followed that they would be ordered to pay the costs. Now, what we say is interesting in that context is that in fact that context is much closer to the real party context that we're talking about than the sort of case the Court of Appeal was considering in, the Supreme Court was considering in XYZ, which is the concept of intermeddling. The Ree Jones case is much more synonymous with the court looking and saying, well, actually, from the off, the solicitor was either A or the real party, a bit like the Myatt case. The solicitor had a real interest, went outside the usual role of the solicitor. And it's interesting that in that context, that on the Ree Jones dictum, what the court wasn't looking to do was say whether there was some particular conduct in the sense of intermeddling or something done during the course of the litigation that caused specific costs to be incurred. What it instead was doing was looking to see who was the real party, and if they were the real party, they should pay the costs. And we say that, in fact, is consistent with our case, and is consistent with what we will see in the other authorities, which is that when you're looking at the A/the real party case, the sort of cases where you can see a non-party is, from the outset, the instigator of the claim, or the instigator of a part of the claim, then that is the effective causation. They have contributed to the bringing of the claim, and as a consequence, it is just that they should pay the consequent costs. What you don't need to look for is some specific further conduct by them, but also what you don't do, and what we say none of these authorities support, it is saying that you have to apply a strict but-for test of the kind of test that you would see, for example, in a negligence claim. It's important to remember that the immutable principle is the exercise of justice. And in a case where a party is seen as being the real party or a real party, it is just that they pay the consequences, the cost consequences that flow from that, without having to engage in a forensic analysis of whether some or all of those costs might have been incurred in any event. And we will see how this court approached the matter in a case called Farrell, where we say the analysis of this court's decision in Farrell is only consistent, can only be consistent with that analysis of the relevance of causation being correct.
And that's tab.
My lord, I'll come to that in a few minutes, if I may. There's just a couple of other quick points on general points on causation before I come to the specific case of Farrell. So we accept that causation is an important issue to be considered as part of the overall consideration of what's just, but we don't accept it is some sort of but-for fundamental requirement before the court can exercise its jurisdiction. And in that regard, we note that whilst the respondent's case is that they say it is a factor which goes to the exceptionality of making such an order, they expressly accept, at least in the DAMS case, that causation is not a separate requirement.
I think we say it goes to the justice.
Justice and exceptionality. I apologise, I'm corrected. So they say it goes to the overall consideration of justice. They accept it is not a separate requirement, and that's page 49 of the DAMS bundle, paragraph 20 of my learned friend Skelton argument. So, my lord, my lady, just a few further short points on the general principle of causation, then I'm going to come to the credit hire cases. So there are two further cases I invite the court to consider. The first is a decision of Mr. Justice David Richards, which is tab 12, page 353. It's a case called Total Spares and Supplies Limited and Antares SRL. So this is another director shareholder case, and it's a slightly unusual case, but in short, this was a case of an application for a non-party costs order against somebody who owned 90% of the shares indirectly of the company that brought the claim and was the controlling mind of that company. He was called Mr. Gargani. The company was Antares. And it brought a claim, which we can see over the page in the first few paragraphs of the judgment, paragraph 3. The claim was partially successful, but nowhere near as successful as it had been hoped. And the consequence was that the judge ordered the claimant to pay 55% of the defendant's costs. We can see that at the start of paragraph 4.
Mm-hmm.
Mr. Gargani had been held to be an untruthful witness, paragraph 6. And what happened in due course, and it's a little bit tangled, but if we pick it up at paragraph 8 over the page, essentially, just before the trial, Antares, the claimant company, had been asset stripped, for want of a better term. Its assets had been transferred to a different company called AWF, and without going all the way through the judgments, the judge essentially found that that had been done on the instigation of Mr. Gargani with a view to avoiding the potentially adverse consequences for the company of an unsuccessful outcome at trial. So an application for non-party costs was made against both Mr. Gargani and the company that Antares' assets had been transferred to, a company called AWF. And that application was successful. As noted, the losing claimant had been ordered to pay 55% of the defendant's costs. Mr. Gargani was ordered to pay that same full 55% of those costs throughout the entire claim. The company the assets were transferred to was ordered to pay 55% of the costs since the time of the transfer. Slightly different orders. But one of the issues that cropped up was the issue of causation in this specific context. Mm-hmm. And at page 367, paragraph 50, it was expressly accepted by the applicant, who's represented by Mr. Tager, that the transfer to AWF had no causative effect on the costs incurred by the claimant. It was only if Antares would not have defended the claim but for the transfer could it have been said that there was a causal link between the transfer and the claimant's costs. There's no evidence that this was the claim and nothing in the circumstances from which to infer it. If we then go on over the page to paragraph 53, the judge quoted from Court of Appeal's decision in Arkid and Borchard lines in relation to causation, where Lord Phillips indented paragraph 24 had noted that causation, well, start at the very end of 23, causation is usually a vital factor when considering whether to make an award of costs against a party. And then 24, it's also often a vital factor in leading a court to make a costs order against a non-party. So again, not set up as a fundamental must tick box checklist. And then at 54, having analysed the cases, the judge said, in light of these recent statements, it cannot in my judgment any longer be said that causation is a necessary precondition to an order for costs against a non-party. It will often be a vital factor, but there may be cases where, in accordance with principle, it's just to make an order for costs against a non-party, you cannot be said to have caused the costs in question. And that's what he considered was the case in that case. Just pausing there, we say that there is more than sufficient and more than effective causation arising from the fact that the credit hire companies here are the real parties and can be seen as instigators of all, or at the very least, the most significant part of this litigation. But in any event, we say that causation is an issue, an important issue to be considered as part of the overall justice, but not a fundamental sine qua non. Just to complete the circle in relation to this, at paragraph 57, because we'll see this referred to then in a Court of Appeal case we'll come to in a moment, 4 lines up from the bottom, the judge held that the combination of the transfer, the merger, the dissolution of the company had deprived the claimant of any realistic opportunity of recovering its costs unless a third-party cost order is made. So that was the analysis which was said to justify the order being made, and I highlight that because it's relevant to something Lord Justice Hamblin says in the next case we're going to come to look at. And that next case is tab 22, tab 21, page 462. Tab 21, below page 462.
Yeah.
So this is a case called Turville and Bird in this court in 2016 with the leading judgment given by Lord Justice Hamblin. It's again another non-party cost order against directors. It was a busy time for such applications at this time. And this is a claim, again, we don't need to worry too much about the underlying details, but it was a claim arising out of a purchase of properties made against some developers where the developers went into voluntary liquidation. So a judgment was obtained which was essentially worthless, and an application for non-party costs orders were made against one of the controlling shareholders in one of those companies who was said to have controlled the litigation for both of them. Now, what's of relevance, again, for present purposes, is what's said about causation. And if I can pick it up on page 468, paragraph 22, Lord Justice Hamblin, as he then was at paragraph 22, cites the judgment below and notes at the indented paragraph 69, Mrs. Toman submitted that there had to be causation in the strict legal sense of a loss to the claimant of that or any identifiable sum before a non-party cost order can possibly be made. I do not accept, and again this is the recorder below, I do not accept that submission as a matter of law. The only requirement to make an order is if it should be just, and strict consideration of causation can sometimes interfere with the court's discretionary power to do justice. And then if we can see what Lord Justice Hamblin says about that, and indeed about Mr. Justice David Richards in the total spares case, if we come on to page 469, so again after a review of the authorities, at paragraph 27, His Lordship says, the authorities illustrate the variety of circumstances in which the court is likely to be called upon to exercise the discretion, and the kind of considerations upon which the court will focus, but are not to be treated as providing a rule book. The kind of considerations illustrated include 1. Funding control and real party, 2. Promoting and funding proceedings by an insolvent company solely or substantially for their own benefit, 3. Impropriety in the pursuit of the litigation, or 4, whether the non-party causes cost to be incurred. So those are treated as kinds of considerations which are not providing a rule book or a checklist as we've seen in the other authorities. And then at 28, Lord Justice Hamblin notes then, the second sentence, generally 4, causation is also required to some extent, although it's not a necessary precondition as held in total spares, supplies and Antares. And then he makes this observation, which I know the respondents rely on. In that case, however, there was still a causal link between the non-party's actions and the claimant's cost recovery, in that he deprived the claimant of any realistic opportunity of recovering its costs. The link was with the recovery of costs rather than the incurring of costs. But in both cases, the claimant has to bear costs in circumstances where he otherwise would not have done. Now, we say that paragraph is interesting and relevant for two reasons. The first, the correct endorsement of the relevance of causation in the context of non-party cost orders. And the second is when it is suggested by the respondents that, oh, well, causation was made out in total spares anyway, it's important to note that what was being said, there was not causation in the strict but-for sense, but for the involvement the cost would not have been incurred. What there was causation in the prevention of recovery of those costs after the fact, after they've been incurred. So all the same costs would have been incurred, but it's just that they couldn't be recovered. So it wasn't but-for causation for the incurring. And I would respectfully submit that what Lord Justice Hamblin is doing there is, in fact, stepping back and exercising an overall justice test. You've stopped these people being able to recover their costs, therefore it's just that you pay them. It's not a professional negligence type but-for test, it's an exercise of justice. And the Turville case itself is another example of essentially causation being said to be present because of the deprivation of the ability to recover. So a different type to the classic but-for causation. And we can see that page 471, paragraphs 38 and 39. So the judge's decision below is upheld, the appeal is dismissed, the judge had held there wasn't any strict causation, and Lord Justice Hamblin analyses it as a case being akin to total spares. Paragraph 39 is a case where Mr. Turville took steps to ensure the respondents were deprived of the realistic opportunity of recovering their costs.
Yep.
Finally, on this, just a very passing reference to the very next authority, which is just over the page, which is Excalibur Ventures. This is a decision of this court in relation to the extent of liability of third-party funders to adverse costs. So in other words, this was a third-party commercially funded case where it wasn't in dispute that an adverse cost order should be made against the third-party funders, but what had happened was that the claimants had been ordered to pay costs on the indemnity basis, and the issue is whether the funders should pay costs on the same basis as the claimants had been ordered to pay, to which the answer, it turned out, was yes. Now, if I can just pick up on a couple of observations. The first is page 476. Letter D, the judgment of Lord Justice Tomlinson. So there's a brief consideration of the history of non-party funding, and then at letter D, it's true that the facilitation of access to justice is an incidental byproduct of commercial funding, but that's not the essential motivation of the commercial funder. The commercial funder is an investor who hopes to make a return on his investment. For that reason, justice will usually require that if the funding proceedings fail, the funder or funders must pay the successful party's costs. So just a number of short points there. The first is that this is a classic example of the situation where it doesn't offend against exceptionality for it to be the norm that parties in that situation should pay non-party costs. The second is that the incidental facilitation of access to justice is not a reason not to make the order. There are a lot of nots to that. So you can't avoid the order by just saying, oh, well, by providing this, we provide access to justice if you're otherwise in the crosshairs for a non-party cost order.
Yeah.
And the third point that we would make generally in relation to this is it is now the norm that commercial funders will pay non-party costs. And what we don't tend to see in these cases, in my submission, it is detailed analysis of questions of but for. So, for example, you don't normally get involved in arguments of, well, was this the only funder out there, and therefore, but for this funder having provided funding, could the claimant have been able to bring the claim at all? The position is that because they have funded for commercial purposes, It is just that they pay the consequent costs.
Yeah.
And if I can just pick up, just to finish off those points, page 492, paragraph C. This goes to the /A real party point.
Sorry, page
492, my lord, paragraph C.
492.
492.
Paragraph
C. Paragraph C, letter C.
Letter C.
Sorry, apologies, that's my mistake. No wonder you couldn't find a paragraph.
The position of the funder is?
The position of the funder is directly analogous. The funder is seeking to derive financial benefit from the pursuit of the claim just as much as is the funded claimant litigant. And there can be no principal reason to draw distinction between them. So that's the point that what the court was here dealing with is the idea that the funder should be liable on a different basis, i.e. standard basis, not indemnity basis. But what that illustrates in my submission is the point that this is a classic case again, where more than one party can be said to be the real party to the litigation. Nobody was suggesting in this case, nobody would suggest that the claimants were not a real party. But that does not stop the funders being also seen to be a real party, sufficient for the purposes of making a non-party cost order. The only other point, just to head it off, is that your lordships will see in our skeleton argument reference to the principle of oversubscribed causation by virtue of one of the COVID insurance cases called FCA Arch. I'm not going to overburden my own already struggling mind by taking your lordships to that. It's not a point we say we need to make good. It simply emphasises the point that there can be circumstances where but-for causation is not a perfect answer, but we say it's not a strict but-for causation test here anyway. So, my lord, those are my, and my lady, those are my submissions on the general points in relation to causation. And again, just for your lordships, your ladyships reference, those points are summarised at paragraphs 38 to 41 of the DAMS skeleton argument, which is pages 29 to 30.
Thank you.
Then, my lords, my lady, I'm going to move on to look at some of the specific authorities and then cases in relation to the context of non-party cost orders in the credit hire context.
Your third subheading was the CPR? And the
Sorry, it was. You're quite right. And indeed, the heading on my page says the CPR, and I've given you the wrong heading.
As you know, I'm very pedestrian. I like people to tell me what's coming, and then I can remind them by my notes.
Well, I'm very glad I told you what was
coming. It all works, you see, by making a manuscript note of the headings.
Well, I'm grateful that your lordship has a plan, even if I didn't. So thank you. So, my lord, the first, indeed, the very next part is to go to the CPR and see what assistance we can take from the CPR. So this is at the start of your authorities bundle.
Yeah.
There are a couple of bits that my learned friend relies on. I'm not going to take you to. I'll leave it for him to develop those as he wishes. But can I pick it up at page 45, which is tab 3?
Yeah.
And so this is Quox. This is an extract from the White Book dealing with Quox. I assume certainly in front of this court that the court is very familiar with how the general principles of Quox. I'm going to go straight.
Well, I never know whether I should, but I usually do when Quox arises. I should say that I chaired the subcommittee that drafted this rule. That usually means that I'm responsible for any glitches or unfortunate lacunae in the language. But all those years ago, this was me.
My lord, I think I may have been before this court suggesting that there might have been glitches on this. On this occasion, I'm suggesting to the court that it's a perfect rule, which
a not uncommon position, and I'm sure that we're all very grateful. But having discharged my obligation to express declare an interest, I think I can leave it to you. So where are we going?
So page
44.
48, rule 4416.
Yeah,
Page 48, rule 4416.
yeah,
So as your lordships will know, the general position with Quox is if you have a personal injury claim, you benefit from an exclusion or an exclusion from enforcement of adverse costs orders, save, generally speaking, to the extent of the damages and or costs that you've been awarded. That changed a few years ago following a Supreme Court case of Adelakan, but we don't need to worry about any of that because we're only interested in a specific part of this. There are exceptions to that, and there are two sets of exceptions. One is where the court's permission is required, 4415, and one is where, not required, 4415, and one is where permission is required, 4416, and it's that we are interested in. And so under 4416, orders for costs, sub 1, made against the claimant may be enforced to the full extent of such orders with permission of court where the claim is found on the balance of probabilities to be fundamentally dishonest. And so that was part of the application against the claimant in the Spectra case, which the court dismissed. She was found not to be fundamentally dishonest, but had she been found fundamentally dishonest, she could have been ordered to pay some or all of the costs of the claim against her. Sub 2, orders for costs made against the claimant may be enforced up to the full extent of such orders with the permission of the court and to the extent that it considers just, where A, the proceedings include a claim which is made for the financial benefit of a person other than the claimant or a dependent within the meaning of Section 1 of the Fatal Accidents Act. And then your ladyship will see there are specific exclusions in the parentheses in relation to care, earnings and medical expenses. So those are areas where the rule makers have decided that those claims, even if they can be seen as being for the financial benefit of another person, should not be so seen. In effect, it essentially deems them as not being seen to be claims for the financial benefit of a person other than the claimant or dependent. So we're not interested in the parentheses, we're interested in proceedings including a claim which is made for the financial benefit of a person other than the claimant. And then the next important part is sub 3, where paragraph 2A applies, the court may, subject to rule 46.2, make an order for costs against a person other than the claimant for whose financial benefit the whole or part of the claim was made. Rule 46.2, just for the reference, are the procedural rules dealing with the making of non-party costs order applications. So we say that this is very clear in its terms. What it's saying is quox can be lifted from the claimant if their proceedings include a claim for the financial benefit of another person, but 4416 sub 3, where that happens, the target may instead be the person for whose benefit that was brought by way of a non-party costs order. And that, of course, makes, we would say, perfect sense. Why should the claimant pay those costs if the real beneficiary can be seen to be another person? It would appear to be more just that it be the other person that pays them. Just pausing there, the only other observation we want to make in relation to that rule at the moment is it's relevant to the respondent's argument that by bringing these applications at all, my clients were misusing or abusing the quox regime because quox says that personal injury claimants should be insulated from from costs, and that we are seeking to go behind that either because we're aggrieved with that regime or in some other way we are seeking to undermine the merits of that regime. Well, we say the terms of this rule completely undermine that argument. This rule shows not merely that it is appropriate to do so, but that in fact it may very well be the proper and just thing in that situation not to seek to disapply quox against the claimants, whether they're insured or not, but rather to go against the third party for whose benefit the claim or that part of the claim can be seen as having been brought.
Yep.
Can I then...
Mr. Knight, am I right that the quox protection wouldn't have protected the non-party anyway?
Quox protection doesn't protect a non-party, no. Quox protection only applies to a claimant.
Yeah.
So that's quite clear. We can see that, my lord, from 44.13. So 44.13 contains within it, at sub 2, a definition of who is the claimant for the purposes of this rule. So that's on page 46, very top of 46. And then we can see at the next page, page 47, that the extent of the protection, rule 44.14 sub 1, is that it is orders for costs made against a claimant as so defined that are restricted in terms of their enforcement.
Yeah.
So it is only the claimant that is intended to be protected by this, and we have a very clear steer in 44.16 that not only are non-parties not protected, but indeed that essentially we say justice may require that they be the proper targets of applications. Well, that rule was then given specific guidance at page 51. So this is the practice direction to part 44, and you will see at the bottom of that page there's a specific section headed qualified one-way cost shifting. So I think in your bundle you have a case called You and Liverpool City Council, in which the Court of Appeal, this court made the point that guidance in practice directions is only guidance, and if it misstates the law, then it's wrong. And that's a case advanced by my learned friends, and I'll leave them to develop that point if they wish. And I accept,
that case
of course,
was before the Constitutional Reform Act, wasn't it?
Sorry, my lord.
The rule, the statutory provisions in the Civil Procedure Act, which relate to practice directions, were amended in the Constitutional Reform Act, came into force in 2006, and the case that's referred to was in 2005.
It was.
And so I'm just making the point that the case was before the changes to the law relating to practice directions.
My lord, yes.
I don't know whether that makes any difference, but it certainly struck me as being something that might be relevant.
Well, my lord, it's not my case that I'm advancing in relation to this, but insofar as it's relevant, no doubt Mr. Williams or one of his juniors will address you on that point.
Thank you.
So, my lord, my lord, my lady, in terms of that, so we have the specific provision. The only point I was going to make is that insofar as practice directions are seen as only being guidance, we do say they carry particular force when you have a bespoke practice direction giving specific guidance for a new rule, which is introduced at the same time as that rule.
And which is the bit of the practice direction you're referring us to?
Well, it's paragraph 12.2 is the first bit. So we've seen what it says in 44.16 sub 3, and then we are told examples of claims made for the financial benefit of a person other than the claimant or a dependent. So that's a direct reference back to 44.16.2a, are subrogated claims and claims for credit hire. And then, Lord, the other part of this that I rely on is over the page at 12.5. The court has power to make an order for cost against a person other than the claimant under section 51 of the Senior Courts Act. So that's the foundation stone of the law in relation to non-party cost orders. And rule 46.2, which is the procedural rules dealing with non-party cost orders. In a case to which 44.16.2a applies, brackets little a, the court will usually order any person other than the claimant for whose financial benefit such a claim was made to pay all the costs of the proceedings or the costs attributable to the issues to which 4416(2)(a) applies, or may exceptionally make such an order permitting the enforcement of such an order for costs against the claimant. And B, the court may, as it thinks fair and just, determine the costs attributable to the claims for the financial benefit of persons other than the claimant. Now, accepting any reasonable qualification that is placed on the use of practice directions, we do say that this is of some importance. Firstly, the rule makers were not saying in every case of credit hire a non-party cost order must be made. I don't remotely try and advance my case that high by reference to this. What I do say is quite clear is that when 4416(2)(a) and 4416(3) were being introduced, one of the contemplated targets was claims for credit hire. The second point I make in relation to this, and it goes in particular again to this argument that we are some way inappropriately trying to get behind quacks, is that the guidance at 12.5a makes clear not merely that it is appropriate to consider pursuing the non-party rather than the claimant, but that that is what is usually expected, and it would be exceptional, that's the word used, to make the order against the claimant rather than the person for whose financial benefit the claim or that part of the claim can be seen to have been made. And the third point that we make is in relation to 12.5 sub B, which we say is entirely consistent with our position in relation to the relevance of what I'll loosely term in a not strict but for sense, causation. It is part of the overall exercise of justice under the contemplated non-party costs order that the court, on frankly what would be a broad brush basis, makes a determination of what it's just for the non-party to pay. And note, there's no concept in there of saying, well, in that situation, can it be said, because it will almost invariably be able to be said, well, the claims were brought in the claimant's name and they had some kind of interest. Therefore, you've got to analyse it on a strict but-for causation basis. No, you analyse, in my submission, whether it can realistically be said that the claim or the part of the claim is being brought for the financial benefit of the third party, and if so, the court does its best to attribute the relevant element of the costs. Even if it could be said, well, it was the claimant's claim and the claimant had a claim anyway and would always have brought a claim. That's not what the rules and the practice direction are anticipating. Again, it's been dealt with in the authorities, albeit not at this level, only at High Court level, but it's a position we don't dispute. And in my submission, it's fairly obvious on the rules. Neither 4416 nor the practice direction, of course, create a new jurisdiction. They are reflective of the non-party cost order jurisdiction, and we can see that from the references to Section 51 of the Senior Courts Act. We can see that from the references to CPR 46.2. But we do say they are important indications of how it was understood when these rules were made. These rules were intended to work. The Lords, my lady, unless you have any questions on the rules, I was then going to move to the cases.
Yeah, credit hire.
Now where I thought I was.
Yeah.
I'm going to move to the cases on non-party cost orders. And what I intend to do, that there's one case I'll take your lordships, your ladyships, to briefly, which may take us up to the lunch and adjournment. I'll try to see how it goes, but we're nearly there. And if it assists, I am running slightly ahead of time.
Oh, well done. Right, so which tab?
So it is tab 2, page 65 of your ladyships, your lordships bundle. So this is the case in the House of Lords of Giles and Thompson. This is to do with the wider issues in relation to credit hire, and in particular it's one of the many cases setting the parameters of credit hire claims, and this is the case that was dealing with the question of whether the credit hire agreements could be seen to be shampitous, which the answer was no, they weren't. I don't intend to go through all of the detail of this. I know my learned friend relies on some parts of it. As I understand it in broad terms, he relies on this case to establish the point that in order to bring a credit hire claim, the credit hire claimant has to have a genuine contractual liability to the credit hire company, and therefore, as I understand his argument flows, the claimant therefore has a financial interest, and therefore it can be said that the claim for credit hire is being brought to their benefit. Now, I don't want to repeat the points I've made already by reference to the terms of the credit hire agreements and various other aspects, but we say, whilst we acknowledge that it is correct that the claimant has to have a financial interest, we say that the reality is that the core financial benefit flows to the credit hire company, and indeed we say DAMS has been pretty open about that in the documents that we saw earlier. I also note, just for your lordships and your ladyships reference in paragraph, that, your lordships and ladyships reference, that in paragraph 15 of my learned friend's skeleton argument in the DAMS case, which is page 47 of your bundle, so that's paragraph 15, page 47, DAMS at least accepts, to quote, in terms that the credit hire agreement is a de facto no-win, no-fee agreement, and that DAMS had a commercial interest and stood to benefit financially. So that's page 47 of the DAMS bundle, paragraph 15, which is an acknowledgement of the reality. So I'll leave it to my learned friend to develop any further points he wishes to in relation to Giles and Thompson. I just wanted to pick up one point, which is page 87. Sorry, I said page 87. Apologies, it's page 88. In the speech of Lord Mustill, and it's between letters A and B, and it's the final sentence of that paragraph. If motorists are found to have been tempted by hire companies into unnecessary hiring of substitute vehicles, in other words, their claim fails, the claims will fail pro tanto with consequent orders for costs, which will impose a healthy discipline upon companies. So it has been along the position that credit hire companies in this situation should have been aware that they were on the hook for costs of failed claims, and indeed that healthy discipline of them being vulnerable to such costs is one that we think is important, and we would encourage this court to endorse. Well, that's Giles and Thompson, and in fact there's I think 6 or
I mean, it is right to say that Giles and Thompson is, I mean, the primary issue there was Champetier maintenance.
It was.
And it is now over 30 years old.
Yes.
And the issues that arise in this on this appeal, to my eye, are somewhat different.
I would absolutely agree, Lord, which is why I've not spent much time in it, because I don't take issue with any of the points made about Champetier maintenance, and indeed they've been established for 21 years.
Yeah.
As I say, the point I take from it is, well, the 2 points. It is one that essentially this If it hasn't been, and we say it has been, and you can see it from the DAMS documents that we looked at, where they expressly talk about the business risk of being subject to adverse cost orders, but if it hasn't been part of the business models of credit hire companies for many years that they're at risk of paying adverse costs in failed claims, it certainly should have been. It is the first point. And the second point is that we say there's patently nothing wrong with that, and indeed the discipline that's referred to of being at risk of such orders is an important one. Ordinarily, litigants, subject only to the Quox rules in personal injury cases, conduct their litigation subject to the salutary risk of adverse costs. And if if credit hire companies are going to be seen as the effective instigator of part of these claims, then we say it's important that they should also be aware that they are at risk of non-party costs if those claims fail.
Yeah. Okay, well, is that a convenient moment for you?
My Lord, if it's convenient for the court, or a few minutes earlier, if it's convenient for the court.
All right, well, if you're making good time, then that's fine. We'll come back at 2. Thank you very much.
Thank you.
All those in favour?